Lady, if I can just very shortly finish off our submissions on effective remedy. All I propose to do is, I mentioned that particularly in light of Lord Reid's questions about sanctions,
Well,
and my submission about penal.
do answer them, but I've been having second thoughts over the adjournment myself.
Okay.
About that.
Well, I've mentioned the Koppel case, and all I wanted to do is give you the reference to that. It's 2012 ICRs 354, and what you'll see is that Ms Monaghan was arguing in the context of a pensions case that although there was no financial loss, there should be a remedy, and I was arguing that the principle was a compensatory one, and for once my arguments found favour with the Court of Appeal. So I don't know whether Ms Monaghan is demurring from the proposition that the approach, whether it's pecuniary loss or non-pecuniary loss, is compensatory, where the word compensation appears in the directive, and hence I am able to argue that if the discrimination has not made any difference to the outcome, it's permissible to ask the question, what injury to feelings has the discrimination caused? Now, I conferred with Ms Monaghan over the lunchtime adjournment. She is arguing 2 points under European laws, as I thought. One is access to the court, and the second is effective remedy. I've addressed you on effective remedy. On access to the court, if I may, I'll address you on that briefly. The point she is making, as we gathered obviously from her submissions, is that the ability to argue a discrimination case before the disciplinary panel and or on appeal and or in the administrative court does not sufficiently comply with Article 6 of the European Convention on Human Rights or Article 47 of the Charter of Fundamental Rights. And it's that point that I address briefly, if I may. My answer to it is to rely on the principle of sufficient review emerging from a large number of cases which a number of you have been involved in, that you can look at the process cumulatively and ask whether overall it was Article 6 compliant. And my submission is that overall the test is satisfied through the statutory instruments. If I may, I'll develop that submission briefly. Can I take you to the Ali case, which is volume 13, tab 164. MS, it starts at 4179. As this court will know, that was a case which concerned a decision by a housing authority on the question whether the complainant had been offered suitable accommodation. The route for challenge from that decision by a homelessness review officer of the council was by way of appeal to the county court. The county court did not rehear the case, but essentially entertained arguments based on error of law. The question was whether the two stages of the decision-making satisfied Article 6. Obviously, I don't go to the case to make comparisons of the facts of a housing case with the issues in the present case. I simply go for the principles. If you've got page 4199, at paragraph 74, the court's assessment begins. The core principles emerge at paragraph 75. The court recalls that even where an adjudicatory body determines disputes over civil rights and obligations does not comply with Article 6 in some respect, no violation of the Convention can be found if the proceedings before that body are subject to subsequent control by a judicial body that has full jurisdiction and does provide the guarantees under Article 6. Both the Commission and the Court have acknowledged in their case law that the requirement that a court or tribunal should have full jurisdiction will be satisfied where it's found that the judicial body in question has exercised sufficient jurisdiction or provided sufficient review in the proceedings before it. And of the authorities that you see referred to there, Albert against Belgium was obviously a decision about fitness to practice in the medical sphere, And Crompton was a decision by an army board about redundancy compensation. I point that out obviously in case it said, well, these cases are all about administrative decisions relating to welfare benefits and those types of decisions. At paragraph 77, in adopting this approach, the convention organs have regard to the fact that in administrative law appeals in the member states of the Council of Europe, it's often the case that the scope of judicial review over the facts of a case is limited, and that it is the nature of review proceedings that the reviewing authority reviews the previous proceedings rather than taking factual decisions. It can be derived from the relevant case law that it's not the role of Article 6 to give access to a level of jurisdiction which can substitute its opinion for that of the administrative authorities. In this regard, particular emphasis has been placed on the respect which must be accorded to decisions taken by administrative authorities on grounds of expediency and which involve specialised areas of law. And then over the page at 78, the guidance on assessing sufficiency of review. It's been explained in the case law that in assessing that question, the court will have regard to the powers of the judicial body in question and to such factors as the subject matter of the decision appealed against, in particular whether or not it concerned a specialised issue requiring professional knowledge and experience and whether it involved the exercise of administrative discretion, and if so, to what extent, the manner in which that decision was arrived at, in particular the procedural guarantees available in the proceedings before the adjudicatory body, and see the content of the dispute, including the desired and actual grounds of appeal. And then at 84 and 85 on page 4201, you can see that in considering whether the legislative scheme taken as a whole provided a due inquiry into the facts, the court must also have regard to the nature and purpose of that scheme. Indeed, in relation to administrative law appeals, the question whether the scope of judicial review afforded was sufficient may depend not only on the discretionary or technical nature of the subject matter of the decision appealed against and the particular issue that the applicant wishes to ventilate before the courts as being a central issue for him or her, but also more generally on the nature of the civil rights and obligations at stake and the nature of the policy objective pursued by the underlying domestic law. And then they deal with the scheme at issue in that case, which they conclude did involve the determination of civil rights, but ultimately conclude paragraph 88, no violation in that case.
Mr. Linden, it's my fault. I'm not entirely following this point. Right. When you say look at it cumulatively, yes, you seem to be saying, well, I don't just rely on the appeal hearing, but you can hardly be relying on the panel hearing because that's the hearing which is the hypothetically discriminatory hearing. So what are you adding in for the purposes of your cumulation?
The appeal tribunal and the administrative court judicial review. But I am also pointing out, as you gathered through my laborious trail through the 2008 regulations, that there are key procedural safeguards in relation at the panel stage. Legal representation, the right to object to a member of the panel, pleadings, those sorts of things.
But neither the appeal procedure nor the judicial review, in the case of some error of law below, can provide the particular area of compensation, small though you say it may be, which is available in the employment tribunal.
Agreed. That's I'm distinguishing between the effective remedy point on which I attempted to address you before lunch. And at the moment, I'm addressing Ms. Monaghan's argument that, as it were, moreover, or perhaps the other way around, the process of adjudication doesn't accord with Article 6. So briefly, my submissions are that before the panel, there is a full-blown factual dispute with the procedural safeguards that I've sought to identify. One sees the force of the argument that at least two members of the panel are not independent. It's a specialist panel dealing with policing issues, as I sought to highlight in the passages from the Taylor Review. Here, of course, because you need to look at the particular dispute, the facts were not materially in issue. There will, of course, be cases I accept. For example, you concluded I was a thief based on a racial stereotype example, where factual disputes will arise. But in this particular case, on the question, did the claimant herself get sufficient opportunity to ventilate her case. It was a case based on agreed facts where she was essentially arguing that adjustments should have been made to allow for her disability, and or this should not have been classified as gross misconduct in the light of that disability. There was then, as you appreciate, an appeal to the Police Appeal Tribunal, where in my submission, the members of the Police Appeal Tribunal should be regarded as independent for Article 6 purposes. And we've set out at paragraphs 18 and 19 of our case, I don't take you back to it, the composition of that panel, but very briefly, you've got a qualified lawyer from the Lord Chancellor's list. You've got somebody from the police authority. You've got an ex-chief officer of police, but not from the same force, and you've got a retired officer. So a mixture of as it were, operational specialism and legal specialism. You then have a process which you've gathered from our case is closely analogous to an appeal that might take place, for example, before an employment appeals tribunal, except that there is more scope for the admission of evidence at the PAT stage. And again, in fairness, I don't say that the appeal hearing is a complete rehearing, because you may have looked at the rules already, but when you come to do that, what you'll see is that witnesses can only be called if one of the grounds of appeal is that the fresh evidence has come to light. If what is being argued is that the outcome is the decision is unreasonable and or unfair, as my lord pointed out, then the rules provide that you go off the verbatim record and hear submissions. So I can't say that the PAT is, I can say it's independent in my submission. I can't say that it's a complete rehearing. I can say that essentially it's closely analogous to a judicial process. After that, there is then application by way of judicial review available to the administrative court, which obviously cures problems of, insofar as there are any, of independence, and deals with issues of public hearing. So, therefore, in my submission, cumulatively, the process is fully Article 6 compliant. My alternative argument is that if it isn't Article 6 compliant, the deficiencies are within the margin of appreciation and or justified. And to make that submission, I just need briefly to remind you of Tinnerly, which Ms Monaghan referred to in her submissions. It's A4 tab 34 at MS 1014. At 10:14, I think Ms Monaghan may have taken you to the passage, so I don't reread it to you. But the points, obviously, with which you'll be very familiar are the right of access to the court is not absolute, but may be subject to limitations. There is a certain margin of appreciation, but limitations must not reduce or restrict the access of the individual in such a way as to render the very essence of the right impaired. And then the limitation won't be compatible if it doesn't pursue a legitimate aim and if there is not a reasonable relationship of proportionality between the means and the aim sought to be achieved. No, I shouldn't have said and or, in other words. I should have said and. But my submission is Ms Monaghan accepts that the aims of judicial proceedings immunity are legitimate. My submission is they're equally legitimate when applied to the panel in the present context for the reasons that I've sought to develop. And my submission is also that they are proportionate, bearing in mind my point about line drawing, that they actually apply quite a narrow aspect of the process. And secondly, bearing in mind the redress which is available to the individual in the event that they're not content with the outcome of the panel, plus the procedural safeguards that I've sought to identify. Lady Model said that those are my submissions, unless there's any other point you'd wish me to address.
I don't know if Lord Reid had anything he wanted to. You didn't? No. Thank you. I think not, Mr. Linden. Thank you very much indeed. Mr. Crozier?
Thank you. Sorry, I was just asking something up for me. Thank you, my lords. Just first starting with the Equality Act, Parliament did not address its mind to Heath. I beg your pardon. Parliament did not make any changes to the Equality Act, though we must presume that it would have been aware of the decisions in Heath and Lake. Therefore, we can assume that Parliament did not intend, or at least we cannot assume that they did intend, to provide a right in these circumstances as against the misconduct panel. We have been taken to the history, first of all, of the anti-discrimination enactments, and I should just like to say, my lady and my lords, that in my submission some caution should be exercised in coming to a conclusion as to the historical context for Section 17 and what we see now as Section 42. Mr. Bowen posits the possibility that it was drafted in the way it was because at material times it was the Chief Constable that effected the dismissal, or the police authority as the case may be. I don't know if he's right about that, but what I do say is that there were enormous changes to policing in the 1960s, massive changes. Forces were amalgamated, statutory vicarious liability was introduced, among other things. And we have seen none of the pre-enactment papers. So, for example, the first manifestation of the Section 47, Section 42 provision, the first expression of it, is found in the Sex Discrimination Act 1975. We don't have the parliamentary debates, and we don't have the white paper. I tried to find the white paper overnight, but it's only available from Kew now. It's not online in the National Archives. Now, Mr. Bowen may be right, but I am just discouraging with the greatest of respect this court from concluding that necessarily, because of the coincidence of those two things, the police regs and the drafting in the first incarnation of Section 42, because of the coincidence of those two things, that Section 42 was directed at that. We simply don't know. It may well be Parliament assumed that there would be vicarious liability. Statutory vicarious liability provisions had been acted under the Police Act 1964. There were vicarious liability provisions under all of the anti-discrimination enactments, so we simply don't know. So that's a context point. Moving on to the judicial immunity point, if I may. Again, more particularly the judicial immunity point, but the related issue of why didn't Parliament address it in a context where they knew about Heath and Lake? We don't know why they didn't address it, but it's fair to say that if it was an error, it won't be the only error in the Equality Act. It's already had to be remedied by judicial intervention. For example, the case of Jessamy, which you'll find, I don't need to take you to it, but Volume 9, Tab 116, MS 2704, failed to make specific provision addressing victimisation after termination of an employment relationship, notwithstanding case law before the Equality Act that said it must. Had to be dealt with by some imaginative construction in reliance on EU law. So it won't be the only error. It's also of note that in certain parts of the Act, judicial functions are explicitly excluded. So, for example, for the services provisions, where one is seeking a service, that's outlawed, where there's, discrimination in the provision of a service is outlawed, and explicit exemption in relation to judicial functions. The same in relation to the public sector equality duty. Public authorities must have due regard to the equality objectives in the public sector equality duty. Judicial functions, those exercising judicial functions, are exempt. Now, it might be said, why would Parliament, and indeed Parliament is exempt, why would the Parliament regard it as necessary to exclude those matters that the courts have said already attract judicial immunity? It's difficult to know. But just as it might be said, there's been some oversight in failing to address Heath, it might be said there's been a misunderstanding of the principle of judicial immunity in its entirety, otherwise it wouldn't have been necessary to exclude judicial functions. As to the approach that Mr. Linden has to take to the question of judicial immunity, namely that the Commissioner, in the making of a decision to dismiss in the case of a senior officer, herself attracts judicial immunity, that must be to take the principle of judicial proceedings immunity to an absurd extent. To have your employer sitting perhaps opposite you in her office, telling you you are dismissed, protected against a claim of discrimination because she attracts you. Well, Mr. Linden is saying, no, as I understand it, his argument is it must be, if he's to get through the anomaly, is that the Chief Constable, when dismissing, also attracts judicial proceedings immunity.
That's what I thought he was saying.
It was just that the rules provide that there'll be a hearing at that stage before the CO. That's only, they won't be sitting across each other from a table in that sense.
It was only the way in which he described it.
It's more than that.
But you certainly said that the chief officer was protected by judicial immunity.
Perhaps I exaggerated it for the
certain amount of hyperbole.
A certain amount of hyperbole. Yep. But in any case, what's certainly so is that it's necessary for Mr. Linden, as he acknowledges, if he's going to manage the anomaly as between senior officers and non-senior officers, to say that the Commissioner, the employer herself, a single person affecting a dismissal, with ultimately line management, albeit in policing terms, responsibility, attracts judicial immunity. My submission, that cannot be right. Finally, insofar as the public interest is concerned, because there has been, sorry, not finally, there is one further point, I've got lots of scribbled notes, penultimately, in relation to the public interest point, because it's said, well, policing is special, there is a broader public interest in ensuring that there is a specific scheme directed at managing the various public interests that might be engaged in the context of policing. Well, there is another very important public interest, and that is ensuring that our police force operates without discrimination. And in the context of the Metropolitan Police Force, though it applies nationally, but in the context of the Metropolitan Police Force, that might be said more emphatically, given what we learnt from the Stephen Lawrence inquiry report. And indeed, we will remember, my lady and my lords, that very significant amendments were made, very significant amendments, including vicarious liability, to the Race Relations Act, post the Stephen Lawrence inquiry report, given the very wide public concern about discrimination within the Met Police force. That is a compelling public interest. Finally now, on judicial immunity, that is the prosecution issue. It was said by Mr. Linden that in the context of a misconduct panel hearing, there was effectively a prosecution and defence, so something in the nature of a lis inter partes. In my submission, that's not so. If I can ask, please, that the regulation for my lady and your lordships to turn up the regulations again. Starting, please, with MS page 200. At Regulation 7, provision is made for the officer to be represented where there's a hearing, and then at Regulation 7.4, the appropriate authority may be represented at a misconduct hearing. Need not be, but may be. And then in terms of the procedure at the hearing, page 214, while the ultimate decider of the appropriate procedures is the misconduct panel itself, nevertheless, the rights afforded apply only to the officer. So if one looks at 34.5, the officer's representative may address the proceedings, put the case, sum up the case, and so on. There's no analogue for the commissioner. Now, it may well be that as a matter of practice, a lawyer turns up and sets out the facts and communicates a view, but those rights aren't afforded in the way one would ordinarily expect in a judicial process. As then to the directive, I don't think it's disputed that the police enjoy a right to non-discrimination under the directives. I drew your ladyship's and your lordship's attention to the case of Johnston when I was dealing with Article 6, a Luxembourg case, but referred to by the European Court of Human Rights. Perhaps I should just take your ladyship and your lordships to that, because it's directly on point. Volume 3, tab 28. Your ladyship and your lordships may be familiar with it. It's quite an old case now and regularly referred to. But just to remind you briefly, it was concerned a woman who brought a claim against the constabulary. She was a member of the police force. When it was decided that the Royal Ulster Constabulary would carry firearms, it was decided that only male police officers would be permitted to and required to carry firearms, not women. The rationale for that was that it was said that the carrying of firearms may impede their ability to engage in welfare activities, not something apparently that troubled them in relation to the male officers, impede their ability to engage in welfare activities, and would also be much more striking. So a move away from an unarmed force to arming women was seen to be much more of a significant move in terms of the practice of an unarmed constabulary, or the convention of having an unarmed constabulary. The effect of that was, however, was not that she wanted to carry a gun. The effect was that she lost her job, because in due course they had enough people, or they needed more men to carry guns, consequently had fewer posts for the women. So she brought a claim of sex discrimination, and a national security certificate was relied upon. You'll recall I addressed this yesterday, my lady. Procedure now gone, but there was an absolute certification process under the old law. And at paragraphs 17 to 21 at MS 8023, keep an eye on the time, I think I started at 30. MS 802, to start with, paragraph 16. This is the just forgive me. Just check I'm on the right. Sorry, just bear with me. I'm so terribly sorry. Yes. 16, the Commission takes the view that to treat the certificate of a minister as having an effect such as that provided for in Article 532, that is conclusive evidence, is tantamount to refusing all judicial control or review and is therefore contrary to a fundamental principle of community law and to the directive, so precluding of judicial control. As far as this issue is concerned, it must be borne in mind, first of all, that Article 6 of the directive requires member states to introduce into their internal legal systems such measures as are needed to enable all persons who consider themselves wronged by discrimination to pursue their claims by judicial process. I emphasise judicial process. It follows from that provision that the member states must take measures that are sufficiently effective to achieve the aim of the directive, and they must ensure that the rights thus conferred can be effectively relied upon. Requirement of judicial control stipulated by that article reflects a general principle of law which underlies the constitutional traditions common to member states, citing 6 and 13. And then down, as the European Parliament, Council and Commission recognised in their joint declaration, and as the Court has recognised in its decisions, the principles on which that conventions must be based must be taken into account here. And then over the page, by virtue of Article 6 of the directive, interpreted in the light of the general principle stated above, all persons have the right to obtain an effective remedy, that included Ms Johnston, in a competent court, I emphasise, against measures which they consider to be contrary to the principle of equal treatment for women and men laid down in the directive. It's the member states to ensure effective judicial control as regards compliance with the applicable provisions of community law and of national legislation intended to give effect to the rights for which the directive provides. A provision like section Article 53(2) requires a certificate such as the one in question in the present case to be treated as conclusive, etc. And then 21, the answer to this part of question 6 put by the Industrial Tribunal must therefore be principle of effective judicial control laid down in Article 6 does not allow a certificate, and so on. So effective judicial control, wholly applicable to the police, no degree of discretion or margin or anything of that sort in the context of policing. We say the misconduct panel is certainly not a body that exercises judicial control, and of course there isn't a coincidence necessary coincidence between a court or a judge and a body that attracts judicial immunity. As Trapp made clear and Heath made clear, the cases they were concerned about were bodies that were akin to judicial bodies. What the directive is concerned about is access to a court. Access to a court in the terms understood by Article 47 of the EU Charter and Article 6 of the Convention. As I've indicated, we say that the misconduct panel is not a court in the way anticipated. It is not exercising judicial functions proper. My Lord Reed's already referred to the aquarium case, the Royal Aquarium case, which talks of the judicial mind, the dignity of the judiciary, the specialisms they bring to the task. We're not talking here about a court, and the same is true of the Police Appeals Tribunal. Firstly, it's not independent. Parties are, forgive me, its constitution is determined by a decision of MOPAC, which has ultimate responsibility for the Metropolitan Police Force. Perhaps I ought to take you to that. Volume 5, tab 44. We see here the Police Act 1996, which establishes the basic context, doesn't provide the rules, but the context for the Police Appeals Tribunal. And if I can invite, please, the court to look at page 1206, Schedule 6. In the case of an appeal by a member of a police force who's not a senior officer, so that's the territory we're in, the Police Appeals Tribunal should consist of 4 members appointed by the relevant police authority. So the appointment is done by the police authority. And the proceedings are, Mr. Linden has already told you, are held in private. So that doesn't, in my submission, meet the requirements of Article 6 or Article 47, and so discharge the obligation under the directives to secure effective judicial control. And nor does judicial review, because it doesn't have the power to give effect to the obligations under the directive to secure a remedy for discrimination. So it's judicial control over the enforcement of the obligations in the directive, and that is to secure a remedy for discrimination. And we have flagged up for you in our printed case, the case of Michalak. It was actually against the GMC, but it was not in respect of the decision of the tribunal, but in respect of investigations. Michalak, which is at tab 128, volume 10, MS 3085, paragraph 46. It's not adequate to meet the requirements to secure a remedy for discrimination or a hearing in respect of a discrimination complaint because of its limited scope. So even taking account of the jurisprudence from the European Court of Human Rights that says in determining whether or not Article 6 is met, one can look at the whole package of measures. Even having regard to that, we're not, so far as Mr. Linden's submission is concerned, in my respectful submission, we're not near discharging the obligations under the directive to secure judicial control within the meaning of Article 47 and Article 6. There is no place within that scheme where a discrimination complaint can be explored and vindicated. In addition, the case law from Luxembourg makes clear that where one is given effect to a remedy under a directive, it's not enough to say, for a state to say, we haven't secured you a remedy in accordance with the ordinary domestic procedure because of oversight or otherwise, but we shall fill that lacuna by providing you with a different route to gain some remedy otherwise. If I can take you very briefly to the impact case, which is at volume 3, tab 27. So this is to deal with the point, well, you can get your access to judicial control and you can get your remedy through pattern reinstatement and ultimately a judicial review, though you can't get it through the employment tribunals. Volume 3, tab 27, MS 690. MS 690. It's involved a slightly different issue, but my submission a similar point ultimately. In that case, there'd been a failure to transpose properly by Ireland the Fixed Term Workers Directive. And it was said, well, it doesn't matter because you can get a remedy through the ordinary courts, not the labour courts, but through the ordinary courts, which will secure you a remedy notwithstanding our failure to properly transpose, and therefore accord you a remedy through the labour courts. And at 757, MS 757, paragraph 43, in that regard, it's important to note that the principle of effective judicial control is a general principle of community law. The court has consistently held that in the absence of community rules governing the matter, it's for the domestic legal system of each member state to designate the courts and tribunals having jurisdiction and to lay down the detailed procedural rules governing actions for safeguarding rights which individuals derive from from community law. Ignoring the citations. 45, member states, however, are responsible for ensuring that those rights are effectively protected in each case. 46, on that basis, as is apparent from well-established case law, the detailed procedural rules governing actions for safeguarding an individual's rights under community law must be no less favourable than those governing similar domestic actions, equivalence, and must not render practically impossibly or excessively difficult the exercise of rights conferred by community law. Those requirements of equivalence and effectiveness which embody the general obligations on member states to ensure judicial control under community law apply equally to the designation of the courts and tribunals having jurisdiction to hear and determine actions based on community law. A failure to comply with those requirements at community level, just like a failure to comply with them as regards the definition of detailed procedural rules, are liable to undermine the principle of effective judicial control. And then 49, it's in the light of those considerations that the referring court's first question must be answered. And then 51, winding it up, in those circumstances where the national legislature has chosen to confer on specialised courts jurisdiction to hear and determine actions based on the legislation transposing the directive, the obligation which would be placed on individuals in the situation of the complainants who sought to bring a claim based on an infringement of that legislation, which hadn't been fully implemented, before such a specialised court, to bring at the same time a separate action before an ordinary court to assert the rights which they can derive directly from that directive. So pausing there, they have to go to another court to secure a remedy and secure judicial control because the directive hasn't been fully transposed, so doesn't afford them access to the labour court. So to require them to go to an ordinary court to assert the rights which they can derive directly from the directive in respect of the period between the deadline for transposition and the date on which transposing legislation into force would be contrary to the principle of effectiveness. Result in procedural advantages and so on. So simply saying, well, you can have your misconduct hearing, you can then go to PAT, and then if you're not happy with the result, you can go by way of judicial review to the ordinary courts, doesn't meet the obligation under the directive, where Parliament's chosen to secure effective judicial control and remedies in relation to rights under EU law and in the employment sphere, decided to confer jurisdiction for determining those complaints on the tribunal, not other courts, and certainly not the ordinary courts, with the cost implications and otherwise. As to sanctions, these are related issues, judicial control and sanctions. It is true that, broadly speaking, states have a discretion as to the measures they introduce, so long as they're dissuasive, proportionate and effective. The UK has decided to address those requirements by the introduction, among other things, of compensation, including compensation for injury to feelings, and where the treatment is sufficiently serious and egregious, aggravated damages. Reinstatement, therefore, does not meet the requirements of the UK's chosen compliance with the directive, and in any event, it is, in my submission, inadequate. It's inadequate indeed for the reasons Mr. Linden himself gave when he talked about reinstatement in the employment tribunals for unfair dismissal. He says they're commonly not sought and they're commonly not, the orders to reinstate are commonly not complied with an employer choosing to make payment by way of compensation instead, because by that time, often the relationship of trust and confidence has broken down. Now, what is anticipated here is that the misconduct hearing dismisses an officer. She waits, unemployed, almost certainly without the ability to claim job seekers allowance because she's been dismissed, so will be surviving on income support if she wishes to exercise her right to appeal, waiting for the appeal to happen and hoping she'll be reinstated. It is very likely that the relationship of trust and confidence will at least have been damaged during the course of that process. And it's also very likely that such a person will have found themselves another job so that they can pay their mortgage in the meantime. Further, and finally on sanctions, subject to me checking my notes again, further on sanctions, of course, the argument that Mr. Linden makes in respect of judicial immunity, so one can't go to a tribunal but one can go to PAT, would apply equally to other decisions of the misconduct hearing panel. And if I can just remind, please, your ladyship and your lordships of what they are, and ask you please to go back to volume 1, tab 5, MS 215. MS 215 in relation to misconduct proceedings, at a misconduct hearing, one can get management advice, which will be recorded, of course, on your personnel file, a written warning, a final written warning, which can ultimately lead to dismissal, as well as dismissal itself. Now, in the event of a management advice, written warning and final written warning, they can be appealed to the PAT, but there will be no compensatory relief. In the case of reinstatement, at least, one's back pay and pension entitlements are paid if reinstatement occurs. In relation to a written warning and a final written warning, there is no compensatory relief at all. So one, at its worst, can be subject to a final written warning on the grounds of one's race, gender, or disability status, and apart from having that warning set aside by a non-independent body, the officer concerned will have no remedy at all for the discriminatory animus or grounds leading to that warning or other disciplinary sanction. I should say too, just for completeness, that not only can a tribunal award compensation, but as your ladyship and your lordships no doubt know, they can make recommendations to an employer as to how to conduct themselves in the future. And where the complaint is one of sex discrimination, they can now direct that an equal pay audit take place. No such provision, of course, made in the police appeal tribunals. think that's everything. I think that's everything. If I just give one moment to get my... I think that's everything. I will only be repeating myself, my lady and my lords. But just to sum up, then, we say judicial immunity doesn't apply. There are compelling public policy reasons why it shouldn't be extended to a tribunal of this sort. And in any event, EU law compels a remedy, so judicial immunity has to be set aside to the extent that EU law requires that it be so, and access to a court and effective remedies granted in respect of the rights afforded directly by the gender, etc., equality directives. Unless there's anything my lord.
Do you say that we have therefore, supposing that we were to accept at least the EU law part of your submissions, do you say that we must therefore read section 42 in such a way as to allow a remedy against both the panel members and the chief officer?
Yes. And of course, in the case of a warning or management advice, that's the panel members. And as I've indicated, there would be no remedy otherwise at all. And yes. And how that's done, as I suggested yesterday, doesn't matter terribly, as the courts have made clear. It's not necessary to descend into a drafting exercise. It's simply necessary to say that where there is a directly effective non-discrimination right conferred by the directives, then that must be given effect to in the ordinary way through the employment tribunals, where that arises in the context of employment, outside of employment, because the equality directives extend that far now, outside employment, then it will have to be in the county court in accordance with the provisions addressing enforcement. Outside employment, where an assessor can sit, specialist advisor on discrimination law, and so on, with the ordinary protections.
Enormously general. An enormously general disposal.
Well, the disposal...
Where one could, if so minded, make the bespoke...
For here?
For this.
My lords, yes. But if the argument, if the principle is accepted that there must be a remedy for the directly effective rights under the directive through the Equality Act, because that's the mechanism the UK has chosen to discharge those obligations, then the answer to this question is simply to say, in circumstances where there is a directly effective remedy, as against the police, then effect must be given to it either through Section 42 or otherwise. The problem doesn't arise outside the employment field in reality, because outside the employment field, the ordinary vicarious liability provisions in the Police Act would apply. Section 88, as you know, requires that there is ordinary vicarious liability. So anything done by a police officer, for example, in relation to effecting a discriminatory arrest, would simply be caught by Section 88. We haven't gone to Section 88, it is in the bundle. The peculiarity in relation to the employment field is simply this restrictive provision under Section 42, which doesn't exist elsewhere in the Act. So elsewhere in the Act, vicarious liability attaches either under Section 109 in the ordinary way, as appears to be accepted, or under Section 88 of the Police Act, which confers ordinary vicarious liability, I beg your pardon, provides for ordinary vicarious liability in the case of unlawful acts. It used to be torts, as my lord may remember, and that was extended to include, I can't forgotten the next, 2002, extended in 2002 to cover all unlawful acts, not just torts. Quite why, we don't know. I'd like to argue that it was because it was discovered otherwise the Equality Act didn't meet the requirements of the directive, but I think not. So far as I can find anything on it, it's suggested that it might have been to cope with the Human Rights Act, which may not properly have been regarded as a statutory tort, but an unlawful act. But I don't know. I'm supposing. But in any event, the ordinary vicarious liability provisions under the Equality Act or Section 88 of the Police Act would deal with the position probably completely outside employment, and the likelihood really is that the vice is in section 42.
I just thought Mr. Linden might want to get to his feet. Yes.
Know me too well, my lady. I only wanted to reply, if I may, on the impact case because it wasn't addressed first time round, and only to do so very swiftly, if I may. The impact case appears to be relied on, as I understand it, by Ms Monaghan for the proposition that the judicial control test will be failed if you have to bring your directly effective rights in a different court to the court in which you bring your claims based on domestic law implementing EU law. If that is the proposition, I invite you to reject it. The overarching test, as the court knows, is whether the arrangements make it impossible or excessively difficult for EU rights to be enforced. In the impact case, there was some sympathy for that proposition because what you had was the same dispute about fixed-term contracts. It's just that there was a gap in a period of time when the directive hadn't been implemented. And Ireland was saying, well, it doesn't matter because they didn't deal with the gap in another court. In the present case, what you're concerned with is the proposition that different claims can be brought in different courts. A raft of claims caught by the employment tribunals, and then claims which seek to accuse the panel members of discrimination to be brought through the statutory instrument procedures. Ms Monaghan made the argument based on impact that you had to bring all of the claims before the same specialist court. In my submission, it's permissible to require that the claims are brought before two different specialist courts. In the case of the run of claims in the employment tribunal, in the case of decisions about whether you should or should not hold office as a police constable, dismissal decisions through the statutory instrument procedures. And as I've submitted finally, insofar as there are limitations and or failures to comply fully with Article 6, the justification defence is available, and you have my submission, that such departures as there are justified. Well, I'm very grateful for the opportunity.
Yes, well, I realise that Miss Monaghan had introduced one or two cases that hadn't been introduced before. It is your right to respond on them.
Which we've dealt with in writing, and I don't know. Thank you.
Thank you. Well, thank you to everyone for your submissions, both oral and in writing. And that includes, of course, to both interveners, because we have written submissions from Mr. Herbert, who was here this morning, but I think is no longer with us. We shall, of course, take time to consider what the answer to these knotty problems may be. Court is now adjourned.